How do you contest a will in Ontario? What I mean by contesting a will is you know that there's a will in place and you don't like what it says. Maybe because of your relationship with the person who had died, the deceased, and from what you know about them, that you would not expect that they would leave everything to this person. You think that something nefarious went on. How can you get that will thrown away and the statute will take over so that it passes to spouse and children and so forth? Because that's what would happen as if you died without a will. So in order to do that, you have to contest the will and have it thrown away. There's a couple of different grounds where you can have a will thrown out. One ground, which is common, and most people don't realize this, is that wills have to be signed properly and formally in the presence of two witnesses of capacity who are not beneficiaries. They need to be of age. It needs to be signed by the testator, the person who's actually making the will. These formal requirements are crucial. If they are not followed, then that in and of itself could be grounds to have the will completely thrown away. There's other grounds as well: fraud or undue influence or duress. In other words, that someone made a will under duress. They were threatened with a gun to their head. Well, that you can, if you have the evidence to prove it, you can have the will thrown away. Undue influence is also a very common situation where you have two people of unequal bargaining power, where you have maybe someone who is taking care of the person who is making the will and kind of using their sophistication and power over the person making the will. They're able to have that person leave all of their assets so that to the person who is more powerful in that situation. So that could be another ground. And then another common ground is testamentary capacity. Does the person who's signing the will understand what's going on? Do they know what they're signing? Are they of sound mind? And there's different tests to make, but if you think that, oh, there's no way that the person who wrote the will is of sound mind and knew what they were doing when they were doing it, you can challenge that, and you can obviously use doctor's notes and experts to do so. So it's very important that when you make a will, that you're doing it formally with the correct witnesses and doing it properly. Otherwise, the will can be contested and thrown away.